We've examined various methods the negotiating parties can use to break stalemates. But what happens when these efforts fail? What alternatives exist at a complete impasse when the parties are at a win-lose confrontation? To examine these alternatives, I interviewed 6 individuals who have vast experience serving as third parties in the resolution of conflict. In our discussions, they provide insights on how third parties build negotiating leverage, and also methods and tools which negotiators can use to break win-lose confrontations and generate the search for compromise settlements. Our first interview is with Mr. Robert Coulson, President of the American Arbitration Association. I asked Bob to give us some background on the association, and in doing so, he gives us an overview of third-party interventions which can be used to resolve conflicts which are hopelessly deadlocked. In particular, he focuses on arbitration and why it's being more frequently used to settle disputes in a wide variety of negotiations, from family disputes to labor management and buyer-seller negotiations.
The association is a 52-year-old nonprofit organization that provides arbitration and mediation services on a nationwide basis. We have 23 regional offices in various cities around the country. We handle about 45,000 cases a year through these offices. Now, in most cases, our services are to bring the parties in contact with the panel of arbitrators, arbitrators who can hear their cases and make decisions on them. We handle labor arbitration, mostly grievance procedures under the collective bargaining contracts. We handle insurance claims, which are basically personal injury claims, some involving the fault concept, some involving non-fault issues. We also are involved in quite a wide variety of commercial disputes, some in the construction field, some in the textile field, books, publications, many different settings, real estate, and so forth. So that we are involved in the resolution of conflict, mainly, however, from the point of view of using arbitration as a way of resolving impasses between people who are either bargaining their newly negotiated interests or using arbitration to resolve disputes as to the meaning of contracts or the application of contracts. In addition, though, we have in recent years become involved in mediation to a larger degree. We do appoint mediators to work with parties in a variety of kinds of cases, particularly in recent years in the community field. But more than that, and I think our major service in the area of mediation and in the area of helping people learn negotiating skills is to carry out training programs for advocates, both in the negotiating process and also in the grievance and arbitration process. We have about 38,000 people on our commercial panel of arbitrators and about 3,000 on our labor panel of arbitrators. So that the association, in the course of its long history, has achieved a unique status as the place to come for out-of-court dispute settlement. We are listed in millions of contracts around the country. And when you think about it that way, it's a rather awesome responsibility to be relied on by so many businessmen and business lawyers.
Bob, would you describe these various services provided by the association and how they differ from each other?
The arbitration process can be as simple or as formal as the parties want to make it. Its essence is to say to the other party, look, we don't seem to be able to agree, and why don't we ask some reasonable person to make a decision? The only simpler way to do the same thing is to flip a coin. But if the parties are in a complex negotiation, they need the help of an impartial third person. There are a variety of ways that they can get that type of help. They can ask a third person to be a mediator. A mediator, in essence, is simply a person that comes in and tries to assist them in reaching an agreement. The mediator has no power, is given no power to the parties, except that the mediator has the right to talk to them, either together or apart, in any way that leads to a settlement. Or they can ask a third person for a advisory decision or some kind of a fact-finding decision. And they can either agree to be bound by the facts, or they can simply say that once we get that fact-finding report, we will try to negotiate further. At least we'll be negotiating about the same facts. Or they can break their dispute down into parts, and they can try to agree on some of the issues and leave other issues for an arbitrator or for fact-finding. Arbitration is the strongest medicine of all. In essence, it's giving a third party the power to make a decision which is binding on the parties. Now, arbitration is mostly used as a clause in contracts where the parties have agreed ahead of time that it's not to their mutual interest to go to court, so that they'd rather have an arbitration clause. And there are millions of clauses that refer to arbitration under the rules of the American Arbitration Association. But in negotiating the terms of a new contract, it's equally possible to use voluntary arbitration. We have developed a set of family dispute rules, which are interesting because they show the whole process of third-party dispute settlement assistance being used one at a time. For example, we have a mediation process where a husband and wife who are trying to work out the terms of their separation can ask for a mediator to come in and help them. Because husband and wife very often, although they're able to decide what the arrangements will be when they split up. On the one hand, they're emotionally disturbed in some cases. On the other hand, neither one of them has been through this process before, so there are a lot of things they haven't thought about. And they're not used to the negotiating process. Now, a mediator can do those three things, can govern the timing to keep them apart until they're really ready to talk, can help them touch base with reality, what their needs will be, what the children's needs will be, how much property there is, what the tax impact will be, all of these kinds of things that are necessary to consider if the parties are going to come to an arrangement as their future lives that they can live with. And finally, the mediator can help them negotiate, can show them how to put their priorities on the table and share their priorities back and forth so they can come to a final solution. Now, we also have a process called referee, and that's where the parties have negotiated most of the issues between them. But there is one or two issues that they simply haven't been able to negotiate to a conclusion. And there they say, well, we'll put these particular issues before a referee. And although we won't be legally bound by the referee's decision, we say that we'll abide by them in advance. And so when the referee renders his decision, that decision is incorporated in the basic agreement, which is given to a lawyer, and then is taken to court as part of the official legal separation agreement. And then finally we have arbitration, where an arbitration clause can be written into a separation agreement, providing such things as if the husband gets a promotion and makes more money, there'll be an equitable increase in the support. They might agree to that, but if the husband gets a promotion, how much will that equitable increase be? Well, they don't want to have to go back to family court to find out, so they provide an arbitration clause, which makes it possible for an arbitrator to give a final and binding decision as to that. So arbitration is probably the best of systems for resolving impasses between parties. It's best because there can be a mutual selection of the arbitrator. So you can have a person who's familiar with the complicated nature of the dispute. If it's in the textile field, it can be an arbitrator who's knowledgeable about gray goods or about the customs and practices in the textile industry. And so you get a rational, realistic decision from an arbitrator. If you took that same case to court, you might get a decision that was completely irrational, because what does a judge, and certainly what does the jury, know about gray goods? They've probably never heard the word before. Much less do they know what the market acceptance is for a particular line of goods at a particular standard. So arbitration is very important, a very important tool in the commercial field. We think it's going to be increasingly important in the family dispute field and in certain types of community disputes, and of course in collective bargaining in areas where society is not willing to permit strikes to take place, as is the case at police or firefighters or prison guards. Arbitration becomes almost the only feasible remedy that can take an impasse situation and apply the knowledge of a panel of third-party experts to a sensible solution, basing that solution on the realities of collective bargaining in that community.
Bob, I have two questions related to arbitration. First, what are the legal implications if the two parties agree to settle their disputes through arbitration? And second, does an arbitration agreement have any impact on the negotiating process itself?
Well, where the parties have agreed to arbitrate a business dispute or a labor dispute, the law, the national law and the law of most states will require a resisting party to go to arbitration and will enforce the decision of the arbitrator. There's a Uniform Arbitration Act which has been passed by most of the major states, and there's a Federal Arbitration Act which does the same thing for interstate commerce. So that you have a legal framework which encourages the use of arbitration and that enforces the power of the arbitrator. The arbitrator is given his power by the parties, but once he has it, the law enforces that power so that the party seeking to overturn an award or to get out of an arbitration after it started has a very difficult time doing so. What the arbitration agreement does to the negotiators' earlier negotiations is really the most important part of it. By agreeing to arbitrate disputes, the parties are saying to each other, look, we'll negotiate, but if we can't agree, we're going to submit to an impartial person very promptly for a final decision. So now let's negotiate in good faith, because if we don't, the matter will be taken out of our hands and put before an arbitrator. We find that the presence of an arbitration clause in a contract makes it much easier for the parties to negotiate settlements as to the disputes. For example, in the collective bargaining field, about 99% of the grievances are negotiated to a settlement in the grievance procedure, and only about 1% have to go on to an arbitrator, because the fact that arbitration is available strengthens the negotiators so that they're more likely to come to an agreement.
Let's now take a closer look at mediation as another major third-party intervention to resolve disputes. I asked Mr. Joseph Gentile, a lawyer specializing in labor management law, and who serves as a negotiator, arbitrator, and mediator, to give us a description of the mediator's role and the techniques used by mediators to resolve conflict.
Well, mediation is a process whereby a third party, a disinterested third party, is brought into the bargaining environment after the parties have reached an impasse, where the parties have finally said, there's no sense going any further, we cannot resolve our differences, we're in cement. To break the cement, they then invite this neutral third party to come in, and hopefully through his good offices would be able to resolve the differences or assist the parties in resolving their differences. It's a consensual thing in most instances in the private sector. In the public sector, some of the ordinances and resolutions that have been passed by California public jurisdictions have made mediation a mandatory area that they have to go into after an impasse is reached in a bargaining situation. The mediator is usually as effective as his reputation and the respect that each party has in that person. If both parties respect that person from a technical competence standpoint, from a personal standpoint, from a high integrity standpoint, then that person's effectiveness in bringing the parties together, or at least helping them come together, is enhanced greatly. A mediator really has no power or authority over the two parties to force a settlement. So it becomes a skill of his persuasive ability, or his ability to crystallize the issues, or to bring to bear upon the parties a certain amount of influence by virtue of his person. Because the best service that a mediator can really render is to, one, crystallize the issues that are at impasse. Number two, find areas of commonality where there is some common ground between the parties. Three, clearly delineate those areas of impasse and those areas which can possibly be broken, and those areas where the parties, there is no possible ground for the parties to come together. And if nothing else, by taking it and putting it down in a laundry list, the parties at least will know whereof they stand. That's probably one of the best aspects of it. It certainly ventilates the problem areas. It gives it a lot of air, and at the same time it provides a vehicle whereby both parties can save some embarrassment, possibly if they think that's necessary, by saying, gee, the mediator recommended it, therefore why don't we go along with it? That's really the role of mediation in labor management disputes.
What are some of the techniques that you use to actually bring the parties together after you've crystallized the differences, the issues?
Well, as a mediator, you would normally meet with one side at a time, talk to that side and say, all right, as I understand it, this is where you are. Where do you think you can go with this? What's your outside limit? Forgetting everything else, I'll keep it confidential, but tell me what your outside limit is. This with one party.
One party at a time.
Then you go to the other party. You don't break the confidence that the other side has given you, and you say the same thing. What are your outside limits? How far will you really go? At that point of time, the mediator has in his mind the outside limits, and he knows whether they overlap, whether they abut, or whether they just are miles apart, where the Grand Canyon is between them. Depending upon where he ends up at that point will depend upon what strategies he uses. If he finds that they're very close together, then the mediator will attempt to go back to the parties and let the parties talk themselves into the posture where he thinks a settlement can be reached, without exerting his own ideas, or maybe not even making his recommendations unless the parties indicate the same. And when he finds out the areas of compromise and the areas where one side might give, where another side might take, where the trade-offs might be, then he maneuvers the parties into that posture, and when at the proper time he brings the parties into the same room and he lets them talk about it.
How do you maneuver the parties?
The maneuvering of the parties is to get them to talk about the outer limits or about the areas of compromise. Because in most issues there might be 2 or 3 corollary considerations. One might be very important, the other 2 are surface considerations that are there simply for trade-off. You identify those and just let the parties know what the priorities are. In fact, you make suggestions. You don't want to breach the confidence, but at the same time, a lot of your suggestions certainly are channeled suggestions by saying, hey, if this really isn't that important to you, point A might very well be important to the other side. Would you be willing to give up point A, because point A means a lot to them, because possibly they don't think much of point B, and yet that's important to you? How would you react to that? And then you have a dialogue with the parties. Again, it's very difficult to articulate what goes on because a lot of it's facial expressions, gesturing, body language, no question about it. A lot of it is, again, getting back to the basic success or failure of mediation, and that is the respect they hold this person in, where the person might make a recommendation. Hey, why don't, look, if you really need this point, give up the others. You can't have everything. You can't have the whole pie. And you get them in that kind of a frame of reference from a psychological standpoint. Sometimes you have to start selling them on that point. And depending on how intransigent their position is, depending upon how hard you have to sell that position.
Mr. Gentile emphasized the importance of the mediator's role in helping the parties to crystallize the issues and identifying trade-offs which each party would be willing to give up to reach a settlement. At this point, let's examine this process further through an interview with Dr. Joseph Stolberg, a Vice President of the American Arbitration Association and Director of the Association's Community Disputes Services Department. Joseph has served as a mediator in a variety of conflicts involving local police departments and community organizations, school desegregation conflicts, and conflicts between minority groups and government agencies. In our conversation, Joseph relates his experience as a mediator in a community dispute in which an administrative agency for the state of Minnesota had approved the building and routing of high-voltage transmission lines by power cooperatives over land owned by a group of farmers who opposed the routing of the lines, and which resulted in a win-lose confrontation between the power cooperatives and the farmers. Joseph discusses the strategy and methods he used as a mediator in crystallizing the issues and identifying those issues of mutual concern to both parties so that the impasse could be broken. In addition, he describes how he went about building a sufficient level of trust between the parties so that the negotiations could proceed.
We were contacted by the governor's office in Minnesota in a situation in which an administrative agency had approved the routing of a high voltage transmission line, and when the power cooperatives went to condemn lands in order to get their easements across farmland so they could put the poles up, a group of farmers got together to protest the line going across their land. Essentially, they met the surveyors on their property and coerced the surveyors into leaving the land. All construction on the project came to a halt. There were threats of violence. The governor's office was appealed to by both the proponents of the line as well as the opponents. And serious questions about public safety arose, and the ultimate question of whether or not the line should or should not go through the route as it was prescribed by the administrative agency were raised. We were asked to intervene to see if the level of tension could be reduced, the rhetoric reduced to constructive discussions, and to see whether or not there was a way of obtaining a settlement acceptable to everyone.
I'd like to find out some of the specific strategies and tactics and methods you used in that situation.
Surely. First thing was to identify who the parties were, to assess whether or not, from our perspective as an impartial party, what role the governor had in all this. Beyond that, who the protagonists were. Were there only two parties or groups involved? Were there more than two? And our initial discussions were under the context of exploratory discussions. We were there to explain the process of mediation to the parties. We expected no commitment from them, no blind commitment before they engaged in it. So it was an education process, and that takes place all the time in the community dispute sector. What was the role of the mediator? What powers did he have? What issues were ripe for discussion? What were not ripe? Who were the parties? Where would we meet? What time frame would the discussions take place under? Who was paying the mediator? All those kinds of questions relating either to the process of discussions or to the role of an impartial had to be aired, and the strategy one has for who you meet with first, who you don't meet with, how you maintain communication were all things that we had to deal with. The invitation came from the governor's office for exploratory discussions with the parties. We suggested that it be on that basis. I contacted the named leaders of each side. It was presented to us as there being two sides, and I contacted both those persons by telephone. One, to get a better feel for what the dispute involved, and two, to make sure that we were going to be meeting with everybody they thought important. Were there more parties to be identified or more interests? We then, having done that, we went out for exploratory discussions. It happened that the most convenient meeting to take place first was with the opponents of the line, and we met first with them. It was a rather huge meeting. A lot of rhetoric went on. We were accompanied there by the governor, so it was kind of an unusual setting in that regard, in that he was there to attempt to introduce a process for resolving the dispute. So the first meeting we had, it was really kind of a show and tell of 400 or 500 people there, where the process of a mediation was explained, and I sought to get from their designated spokesman what the issues in dispute really were. I obviously had to go back for much more discussions. The next day we met with the representatives of the power cooperatives, their attorneys, and tried to get from them an assessment of what had happened up until that point in time, what they saw as the issues, what, if any, movement they thought possible on their side. And that's the way the discussions began. The strategy really was to assess what issues could be talked about and how you define that issue, and in what perspective, what framework you established in which to discuss that issue. It was my judgment that there was no room for productive discussions if the sole issue was to be, will the line be constructed? The co-ops had invested millions of dollars in this. They had gone through a legal procedure, and they were not about to sit down and talk about that issue. Clearly, that's what the opponents wanted to talk about most. So my job became that of trying to see whether or not there were other concerns that had to be met as well. And it turned out that there were a number of other concerns. Questions about safety of the line, which were kind of independent of where it ran, but just, is this line safe? It was a high voltage transmission line, and there was some scientific data supporting the view that there was an ozone factor which could have been harmful to farmers, to both humans and animal growth and vegetation. That was kind of a separate issue. The question relating to the entire routing and siting process for such plants, there were concerns on both sides expressed about what power cooperatives had to go through to get things like this constructed. There were questions as to the priority of which kind of land ought to have these sites. Should there simply be corridors marked off in terms of environmental planning, corridors marked off for wasteland, essentially, and you run all your highways and all your power lines over that and not touch other parts of the land. There was mutual concern as to the criteria used for selecting such sites. The root question was, should this line continue to go over this property? It remained unabated. But I guess my approach was there enough else to talk about, enough of mutual concern, so that it was worthwhile attempting to reestablish some trust between the parties by focusing on acknowledgedly subsidiary issues, but ones that nevertheless were of importance to the parties. Both parties had lawsuits surrounding many of these issues, so there was a question as what status did the negotiations have with respect to the lawsuits? If you negotiated, were you giving up your rights in the lawsuit? If the cooperatives wanted to proceed with condemnation proceedings, did there have to be a moratorium on that while the discussions were taking place? So there were some procedural issues to set out as well. The thrust, the way I characterize what I was trying to do was really to have the parties in a very tedious process, but over and over again say in their own words what the issues were. Everybody, the rhetoric tends to characterize the dispute in terms of one issue, and then the media picks it up, and then people rush to conflict. I view as part of the strategy for diffusing that, intervening in such a way and probing with the questions to see whether or not there are other issues that have to be dealt with. And if so, what are the priorities then of the issues? How can you frame them in such a way that that it makes sense to proceed with the discussions on some or all of those issues? The legal context in this particular dispute was important because one of the demands made by the opponents was that all construction on the power line had to stop until there was a final resolution of the problem. The co-ops were losing millions of dollars a month, so they said, and they were clearly losing something. So the question became how you were to overcome that, so that part of the strategy of the mediator had to be to call from the parties the range of issues in dispute, an identification based on his or her assessment of what was most important to the parties, what was least important, what things parties would be willing to talk about, and then putting all that in a framework so that the perceived interests were not threatened.
Okay. You talked about putting these issues in a framework so that the opposing parties are agreeable to talking about them. How do you put them? How do you develop this type of framework?
I do it in caucus for the parties. I delve ad nauseum in terms of having them identify what's really important to them, so they have a chance to, particularly to the neutral party, probably the first time, a chance to really just ventilate all their emotions, really all the complaints they have against the opponents or the political process all comes out to the mediator, and that's part of what the mediator's job is supposed to do. So once you can, and I take as much time as is necessary, and one of the things that we tell the parties is that it's a time-consuming process for that very reason. And you do that with all sides and get an idea of one, what's important, and two, what interests have to be preserved. And then it depends on the dispute. In this particular one, the suggested framework came from me. Oftentimes the framework will come from a party after just kind of reassessing their own position. You know, it's preferable to have it come from a party, just in terms of their willingness to comply with it.
All right, suppose their willingness is such that they are not willing to comply. What types of leverage do you use to bring those parties together to discuss these issues?
I attempt to point out the cost of not proceeding. And it can be a variety of kinds of costs. It can be economic costs, it can be public support, it can be political support, it can be political support not just for this project but other related concerns. It can be lack of faith in terms of the constituency versus its designated leaders. You know, if you don't proceed, then the people back home are going to say, well, why are you our leader? It seemed like a decent idea. And essentially, I simply point out the continued cost of not talking to each other. There's no commitment in negotiations unless somebody ultimately has the power to decide. But lacking that, it's what does it cost you to talk? And depending on the extent of the public nature of the dispute, the cost goes up.
Okay, you've set the framework, you've gotten the parties to start talking about some of the issues. Could you give us some further examples of some of the methods that you use to bring about a settlement?
Well, when you bring them to the table, you try as much as possible to, one, know who's coming to the table, two, who's going to be doing the talking, and three, what they're going to be talking about. Oftentimes, in a non-statutory framework of negotiations, unlike labor management relations, one of the issues is who's sitting on the other side of the table. They don't like that person, or he's a loudmouth, or he's an SOB. So you've got to get over those kinds of procedural issues, and it's, from my point of view, if the parties are really polarized when you enter, it's a good idea to get over that before you ever come to the table. But essentially then my role as a mediator, I see, is to make the best negotiators out of all parties. And that just involves a clear delineation of the issues, a statement in a very positive way from the advocates as to what it is they're seeking, that what they're seeking is something the other side can, one, afford to give, two, would not be illegal in giving it to you, and three, that it's really in their interest to give it to you. That the position acknowledges the constraints of the other side, the needs of the other side, and that essentially the positions are supported by the evidence. And you can vary on the details, but the initial position, anyway, as I see it, is for the party that's asking for something to really set the framework, to educate the other side as to why it is they're seeking what they're seeking in as depersonalized a way as possible, and to reduce the rhetoric and really try to make it an argument of principle and fact. And the mediator really, in a caucus, you know, before you bring somebody in, you go over that, you press them on certain points to make sure that they're going to make the best presentation possible. And I do it to all sides. I mean, it's not a matter of trying to hype up one side to make them look good. It's you're there for a very serious purpose. And if the process works, parties will, by definition, go away at least accepting the results and hopefully satisfied, not necessarily exhilarated by it, but at least feeling they got what they needed. So to that extent, it's not a game. It's, or if it is, it's a very serious one.
Another example of a technique used by mediators to get parties to resolve a conflict is related to us by Mr. Arthur King, a vice president of the American Arbitration Association and its director of education and training. Mr. King relates an incident of how a mediator, by leaning toward one side and then the other, was effective in moving parties off an impasse.
Well, there are times when, for instance, a mediator can appear to be leaning toward one side and push the other side. There are times when a mediator can point out that rather than pushing toward one side, indicate that your position is unreasonable. In the process of looking at it as an unreasonable kind of position, the mediator may have an effect on one side, and the mediator can do the same thing with the other side too. Yeah, I recall an interesting situation. Well, I was an observer to a conflict, essentially a conflict between a group of kids who presumably were represented by their parents and an owner of a garage. On the garage, there were small windows, some of which were broken and some of which were intact. Kids had to pass this person's garage every day on their way to school. And the process of passing by, and they were on top of a hill, and apparently the garage was set down below. Now, the hill happened to be a very rocky hill. When I say rocky, it had a lot of little throwing-size rocks. So these kids, in the process of passing by every day, used to stop by this hill, and they would throw rocks, and some of the rocks would eventually go through the glass. So this particular owner was able to spot the kids throwing the rocks one day, and he recognized some of them, so he called the police, and he went over to their house, and he got the names of all of them and so on, and a summons was brought to, I guess it was the local prosecutor. It was in a municipality. And all of the parties were brought together. And the claimant indicated that these kids broke my window, I saw them, I identified them, and so on. The kids were there with their parents. And the mediator, or the third-party person, questioned the claimant, and he also questioned the kids. And the kids spoke freely. With the help of their parents, they were able to I guess, flesh out all of the facts that were involved. Now, interestingly enough, during the course of the discussion back and forth, the parents were there. One of the mothers of a group of the kids pointed out, "How do you know it was my kid? Did you see my kid break your window?" And the man said, "Well, look, your kid was amongst the group, and he was throwing rocks just like they all were." Yeah, but the mother said, "But did my kid break your windows?" And she was doing a whole thing about my kid, and my kid wouldn't do that kind of thing, and so on and so forth. Meanwhile, the kids were in the background saying, "Hey, yeah, we threw the rocks, but I guess one of them broke the window." And this was back and forth, and it was sort of approaching an impasse. And the mediator did a very interesting thing. He launched into a discussion about motherhood. And he talked about mothers and mothers' feelings about their children, and my child can do no wrong, and what kids get away with and what my kids got away with, and how these kinds of things are healthy for kids because kids have to learn to be creative and cunning and so on and so forth. He went into a very interesting motherhood Hershey Bars American flag discussion, and she bought it, and she was very calm, and it was good. As a result of him gently, and sometimes he was somewhat assertive, and he was pushing her. As a result of this discussion, the other party, the claimant, said, "See, they're all alike." And this didn't have any side tones or overtones or anything like that. It was generally about the fact that mothers are prejudiced against, in favor of their kids. The mediator saw what the claimant was doing. He was trying to say, "See, she doesn't have any control, and she's trying to develop creative kids and help them become cunning and coy and so on." The mediator then said to the claimant, "How many windows do you have in your garage?" The man said, "Well, I have a number of windows, but they're divided into small panels." The mediator said, "Before these kids started to throw the stones, were any of your windows broken?" So the man said, "Yes." "But how many?" He said, "Well, I have so many windows in the garage. so many panes of glass that some of them were broken. The mediator asked him, well, did you attempt to fix them? So the fellow said, no. I was eventually going to get around to doing that. So he said, you know, I want you to know that you are partially to blame for this whole process. And the fact that you had a lot of little panes of glass with some broken, and you have a hill behind your house with lots of rocks, throwing size rocks, you know, you gotta know that kids are gonna be kids. So while, yes, I was chastising the mother for the position she took, I also have to chastise you for the position that you've taken. You had broken windows. You had an enticement there for these kids. So you are as much to blame as she and these kids are. And as a result of his discussion in that vein, both parties arrived at a closure. And the questions that came out of both parties, not the mediator, were, how can we resolve this favorably to both of us, since we now realize that we're both to blame? And this was an interesting kind of situation where a mediator dealt with two parties who were almost at impasse, and it worked. It worked very well.